Good afternoon and welcome to PERB's webinar on pre-hearing preparation. My name is Eric Koo. I'm the Chief Administrative Law Judge here at PERB, and with my co-presenter today is Eric Quadros, another Administrative Law Judge or ALJ here at PERB. And yes, I know our names are a little bit similar and it's kind of confusing, but don't worry, we'll get through it. We are calling this presentation PERB issued a complaint. Next steps for parties preparing for unfair practice charge or UPC hearings. Now, as you can see, this presentation is going to focus mostly on the unfair practice charge process, but I think a lot of the tips that ALJ Quadros and I are going to go over will apply in other types of PERB formal hearings as well. We will start with an overview. In this presentation, we're going to go over reviewing and amending pleadings. That's mostly the PERB complaint and the answer to the complaint. Tips and things to think about when getting ready for the hearing. We will then go into law and motion work and other requests made of your ALJ. And the last part will be about preparing witnesses. But before we get into any of that, I want everyone to please note that the views expressed in this presentation are those of the presenters and not PERB's official position on any matter. Content is for general information purposes only and should not be construed as legal advice. Some statutes that PERB administers have unique characteristics that may be different from that may differ from the general principles discussed here in this presentation. Please refer to our specific statutes, regulations, precedential decisions, and other legal authority as appropriate. And you can send any questions you have about this material today or PERB's process to perbquestions@perb.ca.gov.
Okay, so you've navigated the charging procedures, and first things first, what do you do next? Well, we recommend that you read the complaint. And it sounds obvious, but it is important because the complaint determines what will be addressed at the formal hearing. The claims in the complaint may not match what is in the charging document or the UPC, and PERB's Office of the General Counsel, who is charged with sort of navigating the first processes before PERB, OGC may have had a different view of your case. But it is OGC who is authorized to issue unfair practice complaints, which in turn determine which claims should be pursued at hearing and the legal theories supporting those claims. PERB issued that decision in City of Montebello, 2016, PERB decision number or PDN 2491M. And this has happened in hearings before, I believe both Chief Koo and myself, where parties have come to hearing and spent time addressing claims that were outside the four corners of the complaint, which we will see results in all sorts of other side issues, but you really are confined by the four corners of the complaint in this case. And if you find in your review of the complaint that it does not include claims that you expected to be there or that you might wish to clarify, then you may consider amending the complaint. So should you amend the complaint? Well, why bother? As I mentioned, you may wish to add, modify, or clarify claims that are in the complaint. As I mentioned, if a party is addressing claims that are not particularly included in the complaint, the administrative law judge or ALJ may exclude evidence unrelated to the complaint. Alternatively, and I think another reason for amending the complaint that might not be so well known is you might want to remove claims from the complaint. And I say this because keeping claims in the complaint that you don't plan to address during the hearing will lengthen the hearing process. The other party may not only spend time preparing for hearing to address those claims, but they might be asking witnesses questions about those claims, eliciting further testimony, which leads to longer hearing days, more hearing days, and ultimately more time to get a decision. So there are two stages in the pre-hearing process at which you can seek to amend the complaint. The first is an amendment of the complaint before hearing. And under PERB regulation or Reg 32647, you can request to add, remove, or modify any claims in the complaint. In doing so, you will file a motion which must include one, a request to amend the complaint, and two, an amended UPC. Now, under County of Tulare 2020 PDN 2697M, the board clarified that an amended UPC is necessary or required only if you are seeking to amend the complaint before hearing. The amended UPC is not required in its counterpart, which we will get to a little bit later in this presentation. But filing an amended UPC, we do recommend that you do so in track changes so that it is easy for the board agent reviewing the request to quickly move to any modifications of the charge. And also we recommend that the motion may include a proposed amended complaint. Myself as the ALJ, I don't always know if I receive a request to amend a complaint, the exact language that a party is seeking. You as the party seeking to amend the complaint know what you want. You've already had a sense of what you want to add, what you want to clarify. So it gives the ALJ or the board agent just a really easy starting point from which to craft an amended complaint. Now I say that, but I want to acknowledge the language that you propose in your proposed amended complaint may not ultimately be accepted, but again, it gives the ALJ an easy starting point from which to craft an amended complaint.
Yeah, that's very true. And it goes with amended complaints as and any other motions you file with us. You know, the easier you can make it for your ALJ to understand what exactly you want and make it the sort of the actual content of it available, it'll make it that much easier to get an efficient ruling.
So PERB generally favors a liberal amendment of the pleadings to hear the merits of the UPC. And under Eastern Municipal Water District 2020 PDN 2715M and Contra Costa Community College District 2019 PDN 2669, the board has clarified that prejudice to the respondent is considered at this stage, right? If you're filing a pre-hearing motion to amend the complaint, prejudice to the respondent is considered, but it may be ameliorated by a continuance. So the closer in time you get to the hearing in which you file a request to amend the complaint, you may find it more likely that you have bought yourself a corresponding continuance of the hearing. Okay, the second stage for amending a complaint is to amend the complaint during the hearing. And under PERB Regulation 32648, this motion may be submitted in writing or it may be made orally during the hearing. And again, at this stage, an amended UPC is not required. The ALJ will determine if the requested amendment is appropriate, and a determination at this stage necessarily includes the possibility of prejudice to the respondent. At this time, I think it makes sense to also discuss in your review of the complaint, you might also withdraw the complaint, and this can really occur at any stage during the pre-hearing proceedings. But again, under PERB Regulation 32625, a request to withdraw the complaint may include all or some of your claims. It must be in writing and signed, and it should specify whether the request is made with or without prejudice. Now, I do say it should specify, but really under PERB Regulation 32625, the regulatory language says that the request shall specify whether the withdrawal is with or without prejudice. And also, if a complaint is issued, the language further states that the board agent shall determine whether the withdrawal is with or without prejudice. So in Solano Community College District 2020 PDN 2708, the board clarified that the ALJ's notice of withdrawal, assuming they are going to grant the request, the notice of withdrawal must indicate whether the request is granted with or without prejudice. So really, though we're saying you should specify, just go ahead and, as Chief Coos mentioned, make it easier on your ALJ so that they don't have to come back to you and get that clarification. Go ahead and include that in your request. Finally, the ALJ may deny withdrawal requests made at hearing, and that's if the respondent objects to the withdrawal.
Yeah, and I do want to stress what ALJ Quadros mentioned about partial withdrawals. I think sometimes people think it's either all or nothing. We're settling the whole thing, or we're settling nothing. Oftentimes, as you get close to the hearing, parties want to really narrow down what the case is going to be about, what's still in dispute. And so we do welcome partial withdrawals as well as full withdrawals. But let's move on to the flip side. So for every PERB complaint, there should be an answer to the complaint. Answers to complaints are governed under PERB Regulation 32-644, and for the most part, employers must file an answer every time PERB issues a complaint. And believe me when I say that bad things can happen for respondents who choose not to file answers or who do not file their answers on time. So if looking at Regulation 32-644, we'll see that there are both timing requirements and content requirements. So why don't we take those one by one and jump right in. So you'll see right here, the general rule is that the answer to the complaint is due within 20 days from the date that the complaint issues, that is calendar days, and PERB may order a different date for the answer depending on the circumstances, but the general rule is 20 days. It's right there in the regs. I think we also put that in the cover letter for our complaints. And the reason why we stress this so much is because it is very important to make sure you file your answer on time. So don't miss your deadline, 20 days, put it on the calendar and get it filed. If you don't file a timely answer, then you run the risk of having a default judgment against the respondent. What that basically means is that the charging party will prevail in the case without the need for a hearing, without the need to assess the evidence. Essentially, the charging party wins automatically. Now, if you found that you've missed your filing deadline, it is possible to file your answer or any other document late. However, you have to make a request to do so, and your request has to be supported by good cause. Good cause is a legal standard. It applies differently depending on the factual circumstances, but kind of generally speaking, the times that we've found good cause have been things that are short delays, something unexpected came up, there was a sort of a demonstrated attempt to file on time, but for whatever reason, it just didn't happen. On the flip side, things like excessive workload, I got my cases mixed up, I just misread the rule. Those are less likely to have a good cause finding. And the prejudice to the opposing party is considered whenever PERB is addressing whether to accept a late filing. But even if you suspect that the other party is not going to be prejudiced, it does not excuse you from demonstrating good cause. And a couple decisions that discuss that are the Gompers Preparatory Academy case from 2021, PDN 2765, and the City and County of San Francisco, also from 2021, PERB decision number 2757M.
And if I could, Chief Koo, I just want to jump in and reiterate, I don't think it's a problem for a party to file a motion to accept a late filed answer. And when I say it's not a problem, you still have to establish good cause. But I think as an administrative law judge who may sometimes from time to time receive a late filed answer, I appreciate receiving that motion and reading through your reasons that you believe you have good cause for a late filing. I think one of the things that will stick in the craw of a judge, at least for myself, maybe for many of the judges at the Division of Administrative Law, but there have been occasions in which a party has surreptitiously attempted to sneak an answer into the file. And I have to say, it's one of the first things as when I have a case assigned to me, as we're advising you to do, one of the first things I do is I look at the complaint and I look at the answer and try to get a sense of the issues. But it's very easy for me to understand or to see if an answer has been timely filed. And if we're at the 50-day mark and an answer's filed with no explanation of why it's late, that tends to draw a raised eyebrow, I will say.
Yeah, that does happen, and believe me, your ALJ notices every single time. So if you know you've missed your deadline, it's not the end of the world, but do not just try to slip it in because we've definitely noticed that that if something gets filed within the 20 days. And that was actually, I think, the issue in the case on this slide that I neglected to mention earlier, the Regents of the University of California 2018 PERB decision number 2601H. That was a case where the respondent, for whatever reason, didn't file their answer, and then they just filed it sort of a few days before the hearing and sort of hoped for the best. And, without getting into too much detail, it did not end well for that party. Okay, so moving on to the content of the answer, under PERB Regulation 32644, it requires what we call a specific admission or denial of each of the allegations contained in the complaint and a statement of all affirmative defenses. Let's go through each one of those things. So as ALJ Quadros has mentioned, it's really important to read the complaint, review it carefully. That your complaint is going to have a set of numbered paragraphs, and what the answer should be doing is taking each of those paragraphs and either saying that the respondent admits, all of these allegations in paragraph 1, some of the allegations in paragraph 1, and denies the remainder. It's really important to read that carefully, think about what you're willing to admit to and what you have to deny. And collectively, as ALJ Quadros mentioned, the complaint, the issues in the allegations in the complaint and the admissions and denials in the answer are going to really frame what's in dispute. What do we need evidence about? Why do we need a hearing? And you have to be really careful, because if you don't, if you admit or you don't fully and completely deny the allegations in the complaint, that can be viewed as a concession, an admission, and it might result in the ALJ not accepting any evidence on that issue because it was admitted. The same thing is true of affirmative defenses. An affirmative defense is basically a claim by the respondent where even if the allegations in the complaint are true, the respondent should still prevail for this other additional legal reason. The answer requires that the respondent assert all affirmative defenses in their answer. You don't have to explain them. We don't need a brief about it, but you do need to list all the affirmative defenses that you think are going to apply in your case. And so right about now, you might be wondering, well, if it's so risky to accidentally admit something or omit an affirmative defense, why don't I just deny everything? Why not assert, every affirmative defense that's in the Civil Procedure Handbook? I'll tell you why. First of all, it's probably going to irritate your ALJ. As ALJ Quadros mentioned, ALJs are really looking at the complaint and the answer for our guideposts, our map of what this hearing is going to be about. What do we need it to be about? And so if a respondent is denying that they are an employer or denying that they're an employee organization, just very obvious things that just are not really in serious doubt, it's really going to, I think, there's a point at which it's going to suggest that you're not taking the process seriously. And more importantly than that, the more disputes that there are, the more issues that are in dispute, it's going to mean more witnesses, it's going to mean more documents, and ultimately a longer hearing. And so you do want to use your time efficiently, use your client's time efficiently, use PERB's times efficiently. And in addition to that, one other consideration to make is excessive denials or just sort of an overflow of affirmative defenses. It could affect a respondent's ability to file certain kinds of motions to dismiss the case. For example, if the respondent is going to say, based on the undisputed facts, respondent has to prevail for this and this reason. But if we're looking at the answer and we see all of these very basic facts in dispute, then it really is going to sort of jeopardize that legal theory. And don't worry, just like charging parties can amend their complaint, respondents can amend their answer. Unlike with amending the complaint, there is no specific regulation on point for amending answers, but PERB has found that the ALJs, in their authority to hear and rule on motions, does have the authority to grant requests to amend the answer. That was discussed in the Eastern Municipal Water District case from 2020. We've seen it earlier in this presentation, but it's PERB decision number 2715M. Also, regulation 32170 covers the ALJ's authority in a hearing. Now, we look at amendments to the answer in a similar way as we do amendments to the complaint. As ALJ Quadros mentioned, there is a what we call sort of a liberal amendment of pleading standard. Prejudice to the other party, in this case, the charging party, is considered, but oftentimes any harm caused by allowing an amendment to an answer can be addressed through either moving the hearing, adding additional hearing days, or just giving the charging party additional time to consider any changes in the amended answer. And I do want to note that the process I'm describing is specifically for filing amendments to the answer. It's not quite the same as filing an answer to an amended complaint. If the complaint gets amended, allegations are added to it. Under our regulations, PERB can just assume that all of the new allegations in the amended complaint are denied, and so that a new answer isn't strictly necessary in that case. However, your ALJ may ask for an amended answer, and in that case, you should comply. In addition to that, there are maybe instances where the respondent wants to file an amended answer, and I'll give you for example. If there are new factual allegations in the complaint that the respondent doesn't necessarily want to deny, they're willing to admit those things, or at least some of them, then you can file an amended answer, and again, tailor the new complaint and the new answer to what is really in dispute here. In addition to that, adding new allegations to the complaint may give rise to new affirmative defenses that were not raised earlier because those claims hadn't existed earlier, so you may need to amend your answer to add additional affirmative defenses. If you feel like you need to file an answer to an amended complaint, do contact your ALJ to get sort of a filing schedule.
Okay, so we've moved through the pleading stages of PERB processes and have now arrived at sort of what I'll call the pretrial phase, or I guess the pre-hearing phase. So at this stage, you want to begin planning for the hearing process, and you want to begin preparing. You want to prepare well in advance. So you can begin now that you have the pleadings. You've heard us describe how those are really the operative documents for framing the issues at the hearing. You can begin to look at them and decide what are the pivotal facts that you need to prove during the hearing. What will be the real battleground at hearing? And you can begin to find your strongest and potentially weakest arguments for each of those. And in doing so, you can begin to figure out which facts might require additional explanation. For example, if there are signs that one party attempted to notice the other party about an issue beforehand, or if in the case of a disciplinary matter, perhaps there's a work history or lack thereof, which are supportive of the actions of the parties. You want to begin thinking about those and how you'll deal with them at hearing. In addition to disputed facts, you can also get a better sense of, are factual stipulations possible? Are there undisputed facts that we can quickly address? Under PERB Regulation 32207, no hearing shall be required unless the parties dispute the facts in the case. So you can potentially have a fully stipulated record and avoid the time and expense of a hearing altogether. But alternatively, you might also consider whether it's possible to reach a partially stipulated record on the facts that are not at issue. And in doing so, you can submit those stipulations to the ALJ in advance of the hearing. And those are issues that you won't have to address during the hearing, which can, again, lead to a more efficiently run hearing, fewer days, and a quicker opportunity to receive your decision. Now, in identifying all of those facts, that leads us to our following questions. What witnesses will be needed to explain those facts in dispute? And also, you might begin to ask yourself, when are they available? Um, Additionally, what documents are needed to support particular facts, and who can explain what those are? And in looking at the documents that you might need, you might realize, hey, I don't have access to this particular document yet. So you can also begin to identify whether or not you have subpoena issues, which you will need to address during the pre-hearing phase. And we'll get to that in a little bit more detail later. But by answering all of these questions, by addressing all of these questions at some point in your pretrial preparation, you can begin to streamline the legal proceedings by organizing the evidence and witness preparation process. Again, as we've mentioned, you can identify theories that you might wish to abandon. You can also potentially avoid any last minute surprises, which might add stress or fatigue to the representatives or the witnesses during the hearing process. Of course, some level of flexibility and improvisation are necessary during a formal hearing. You never know what's going to come up, but you can also take that preparation and develop maybe, I'll say, a more effective opening statement, or you can help hone your examination strategies in order to put on a more effective hearing. And all of this together further aids in settlement negotiations, pre-hearing motion practice, and avoiding other pitfalls, as you will see in this hearing, or in this, excuse me, in this presentation. Speaking of settlement negotiations, one of the first opportunities to explore those are during the informal settlement conference. This is typically held around 30 days after the complaint is issued, and it is mediated by a board agent from the PERB's OGC. Now, this is an opportunity to resolve the parties' dispute without litigation. We are trying to promote the settlement of disputes without the risk and expense of a full formal hearing. And so it's important to take these seriously. So that said, please come prepared to the informal settlement conference. Representatives with authority to settle the case should attend. And if it looks, after sitting through the informal settlement conference, if it looks like settlement may not be possible, you should also be prepared to answer questions about the hearing if necessary, such as you might need to estimate the length of the hearing. You might be asked to provide available dates for the hearing. And you might be asked your preference for the format of a hearing, whether you want it to be in person or virtual. Now, I will say the ALJ does have the final decision as to the answer of these questions, the scheduling and the format and whatnot, but they do so with the party's input. And so if you have the answers to these questions in advance, that really helps the ALJ in sort of beginning to lay out the next steps for the hearing. I also want to add that if you fail to settle a dispute during the informal settlement conference, this is not your last opportunity to pursue settlement. The PERB has multiple avenues to assist you in this regard. You may ask for that another ALJ be assigned to help mediate further disputes, or you can ask to meet with someone from PERB's State Mediation and Conciliation Services. So we have multiple avenues for you. However, once the case is assigned to an ALJ, we do ask that you communicate with that ALJ if you wish to further pursue settlement. That ALJ does retain scheduling authority, the responsibility to keep moving these cases forward. So we should always keep them in the loop if we're going to pursue alternative settlement strategies. And I do also want to add a shameless plug. Stay tuned for PERB's June 2026 webinar on informal conferences.
Okay, so ALJ Quadros just mentioned some aspects of the hearing format. So let's dive into that in a little bit more detail. As he mentioned, the big question, at least at this stage, is should the hearing take place in person or virtually? In both scenarios, parties have the same opportunity to present witnesses, documents, other forms of evidence, but there are some notable differences that we'll get into. In-person hearings, as the name suggests, those are held where all the participants are all together at a hearing room in one of PERB's 3 regional offices, those being in Sacramento, Oakland, or Glendale. There was a time for any old timers in the audience where we used to travel to do hearings on site at an employer's conference room or a union hall or whatnot. But for the most part, the large majority of our in-person hearings nowadays are occurring in one of PERB's offices. Now, as I said, all the participants come to the office, come to a hearing room. They're all together, and it does have the advantage of being a little bit easier to read things like body language, the demeanor of the participants, especially the witnesses. But you also have to note that parties that are doing an in-person hearing need to bring paper copies of all exhibits and other documents. That means a copy for each party, for the witnesses, and for the ALJ. It also means that, hearings, as ALJ Quadros mentioned, it's a little bit unpredictable. You have to be kind of ready for anything. And one of the things that happens is you can't really predict when a witness is going to be done with their testimony. So sometimes that means the next witness in line has to wait around, sit on a couch, and wait for their turn to testify. And so there are some drawbacks to having hearings in person as well. A virtual hearing takes place by video conference, and our main video conferencing platform right now here in our division is Zoom. In a virtual hearing, parties and witnesses appear remotely from their own locations. They can appear from their office, from their homes, from any other private location that has a good, strong internet connection. Instead of paper copies, exhibits and documents are exchanged electronically before the hearing, and if necessary, they are projected right into the video conference for witnesses, for the attorneys, and for anybody else to see as they're being discussed. And as ALJ Quadros mentioned, parties do have input into the format of the hearing. Some of them prefer an in-person hearing for one reason or another, or the other way, they prefer a virtual hearing. And ALJ Quadros is correct that we do take that into account, but scheduling authority, including over the format of the hearing, is ultimately up to PERB. And I should say one more thing. We've seen this a couple times, not too often, where one party or the other will just not respond when PERB asks them for hearing availability or formatting questions, and perhaps they think it'll put the hearing off longer, but that's really not the case. Parties have the opportunity to weigh in on the scheduling and the format of the hearing, but if they forego that opportunity, we're just going to schedule with the information that we have. So because virtual hearings have just a little bit more of a sort of technical requirement to it, I thought it might be wise to go through some of them. These are some best practices for virtual hearings. Generally speaking, the better your internet connection is, the better the hearing is going to go. For the most part, that means hardwired Ethernet connections over Wi-Fi, certainly over a cellular phone internet connection. For the same reasons, a actual dedicated headset with a microphone is also preferred, just because it gives you that much better sound quality and recording quality. Those are preferred over computer speakers and microphones. Now, your ALJ may request or may order a pre-hearing conference in order to test the virtual hearing equipment and discuss virtual hearing format matters. But whether that happens or not, it is a good idea for each party to test their equipment before the virtual formal hearing, and really test the equipment that you will be using during the hearing. I've had instances where I've done a pre-hearing conference to test the equipment, and then on the day of the hearing, they're in a totally different room using a totally different device, and lo and behold, there's a technical problem with it. So please do think about that in advance. And for the same reason, do test your witnesses' equipment as well. Witnesses can show up to the pre-hearing conference if they want to test things out, or you can test with your witnesses privately. But that's another thing, because I can't tell, I can't speak for ALJ Quadros, but I can't tell you how many times I've seen some audio setting get changed or some software update that has to be run on the morning of the hearing, and it does cause delay, and the delays do add up.
Yeah, I will say these best practices, I don't want to think of them as necessarily just strongly preferred recommendations that we are making here today. They do come from real world experiences. For instance, I had a witness make their appearance in a hearing I had a few years ago, and their face was very, very close to the screen. And I couldn't really see what was going on behind them. I could tell it did not look like a regular room. There were different colors, but we proceeded. But very early on in their testimony, it became readily apparent, and we soon realized that they were appearing from their car while they were on vacation in the mountains, and they were using Wi-Fi from their cell phone. So right off the bat, we had connectivity issues, sound quality issues, which inhibits the ability to develop a record or a transcript. And we also were trying to display exhibits for them, and instead of looking at them on a nice large computer screen, they were trying to zoom in on their cell phone to see them. So it created all sorts of issues. We had to backtrack and schedule a separate day of hearing for them just for that witness, and that could have easily been, I think, avoided by some pre-hearing preparation by their representative. I'll say that. So don't be that person.
Yeah, I think every ALJ has a story like that, and it's possible, it's not preferred, but it is possible that ALJ Quadros was being nice there. We might just say, if your witness isn't ready, then we're not taking their testimony. And so do be prepared in advance. That is a very good idea. Okay, so let's move on to motions. Now, the general rule with motions is covered under PERB Regulation 32-190. And that general rule is motions can be filed before, during, or after the hearing. So pretty loose standard. I can't think of a time that is not before, during, or after a hearing. Once again, the general rule is that responses to motions are due 14 days later, unless the ALJ sets another filing response deadline. And two things I'll say about that response deadline. The first is your ALJ might set a different deadline, so do look out if there is a reason to have a different response timeline, then your ALJ will announce that to the parties. And second, kind of on the opposite of that, is if it is just kind of a regular garden variety motion, don't expect your ALJ to tell you that you have 14 days to file a response. I think most ALJs assume that parties are reading the rules, that they're aware of their filing obligations, including this one. We've already gone over earlier in the presentation what happens when you file a document late. Bad things can happen to you if you blow your deadlines. And so the same good cause standard would apply in sort of late filed responses to motions. So in addition to that kind of standard timeline, motions can be made orally at the hearing. The ALJ will usually have a brief period to accept argument about it. And also some motions have their own special timelines. We talked about motions to amend the complaint as one kind of those examples, and we're about to dive into another type. So there are special rules in Regulation 32-190 about what I'm going to call dispositive motions filed by a respondent. And that's really a sort of covers a whole family of types of motions, including motions to strike allegations from the complaint, motions to defer the case to arbitration, motions to dismiss, including partially dismiss the case. That could also include motions for summary judgment, motions for judgment on the pleadings. For those types of motions filed by the respondent, there is a specific timeline. You have to file those at least 45 days before the first hearing day. And any response to this kind of motion filed by a respondent is due 20 days later unless the ALJ sets a different timeline. Now, what happens if you miss your deadline? If you don't file your motion within that 45-day period, and this, once again, all of these tips are coming from a real place, then the respondent simply, they can't bring the motion until after the charging party completes its case in chief. That means after it finishes its primary presentation of evidence, then the respondent can bring that motion before beginning its own case in chief. And I should say, so we've gone over sort of the basic the basic motion timeline. We talked about this specific timeline for these specific types of motions. In expedited cases, none of these rules apply. In an expedited case, because of the quicker nature of the case processing in those situations, it's typically up to the ALJ to set a motion schedule to determine motion deadlines. And it really would be a good idea for the parties to inform the ALJ what motions they intend to file so that an orderly schedule can be arranged. And just in case you're thinking, expedited cases, how often does that come up? We actually have quite a few expedited cases right now. I think more than I've ever seen as an ALJ in the past, dozen or so years. So it does come up. It is a common thing, and that the parties should be planning ahead if they have an expedited case or if they expect to have an expedited case.
Okay, related to pre-hearing motions are subpoenas, and there are two types of subpoenas that you can acquire before PERB. Under PERB Regulation 32150, it describes this process, and we'll do a deep dive into these over the next few slides. But suffice to say, you can acquire a testimonial subpoena, which compels a witness to come and testify at a PERB hearing. And you may also acquire a record subpoena, which compels an entity to provide documents or other records. Now, when submitting a record subpoena to PERB or when serving one, it must also include a declaration of materiality, just sort of justifying or explaining the relevance of those records to the case that you are in. The reach of these subpoenas, or I guess the effectiveness of these subpoenas, they're effective throughout all parts of California. And blank forms are available on PERB's website at perb.ca.gov/about/forms. Now, the blank forms do have spaces for you to fill in information such as the date of the hearing, the time of the hearing, the case number, and also the locations of the hearings. So for in-person hearings, you will want to include the location of the hearing on the subpoena form. That means the brick and mortar location of one of PERB's 3 offices. And for virtual hearings, you will want to include the meeting login details on the subpoena form. Serving subpoenas. The subpoena must be signed by a board agent before it can be served. And typically, upon receiving a signed subpoena from the ALJ, typically subpoenas are personally served on the target entity or witness. Sometimes a subpoena on a party agent may be served on the party representative. They might accept service on behalf of the agent. But I will say, as I mentioned, you do have to submit both subpoenas to the ALJ for signature. And there are occasions where In providing that subpoena to the ALJ, the party has copied or included their opposing counterpart on the email. And so the ALJ or myself, I have in the past just replied all to that email and provided my signed, the signed subpoena for the parties. But I do also remind the parties that service is the responsibility of the parties. Do not rely on the ALJ's responsive email to effect service on the opposing party if they are included as a recipient. Now, timing, there are general rules for service of the subpoenas. A testimonial subpoena must be served 10 days before the hearing, and a records subpoena must be served at least 20 days before the hearing. Now, if you find yourself in a situation where these deadlines might not be possible, the ALJ may still determine if notice was or could be sufficient. There are opportunities to request that the ALJ shorten the timelines, or if there is a motion by the responding party to revoke or limit the subpoena, the ALJ will look at the circumstances and again determine if notice was sufficient anyways. Now, in producing responsive records to a records subpoena, the requesting party identifies when and where to produce the records. This may be a hearing date, or it may be a non-hearing date if the responding entity has at least 20 days to respond. However, the deadline to respond or to produce responsive records may not be after the hearing unless the ALJ allows. So we focused a little bit on the requesting party's responsibilities when it comes to subpoenas, but now let's also look at the flip side of the coin for a responding party. A responding party may, number one, comply with the witness subpoena or record subpoena, but they may also have other alternatives. They may file a motion to extend a records production date. They may seek to extend the production deadline if, let's say, a records request is voluminous, seeking many records, and there's just not enough time in those 20 days to gather all of the records and turn them over. So if you are going to request or if you are going to file a motion to extend the records production date, it must be filed at least 7 days in advance of the deadline, the original deadline to respond. Alternatively, a party may file a motion to revoke a testimonial subpoena. Let's say if they are arguing that there wasn't timely notice, it wasn't served on them with that 10-day period in mind. The motion may be made in writing or orally at the formal hearing. And in the same way, a motion to revoke a record subpoena may also be filed. This must be filed no later than 12 days after service, and an opposition, if any, is due 6 days later. Now, if a party fails to comply with a subpoena, there are multiple avenues for the requesting party to seek enforcement. They can seek enforcement proceedings where PERB's General Counsel's Office may take action to enforce the subpoena in Superior Court. They may also seek adverse inferences where the ALJ may draw adverse inferences after giving the responding party a chance to respond or provide an explanation for its failure to comply with the subpoena. Alternatively, the ALJ may prohibit the party from presenting any evidence or arguments related to the missing information or witness.
Okay, let's switch gears. Let's talk about continuances. A continuance is basically another type of motion, and it is essentially a request to move your hearing dates. Most of the time that means moving them to a later date, but every once in a while we'll get one where they're trying to move the hearing to an earlier date. Continuances are governed by PERB Regulation 32205, and there are essentially two types. There are what I'm going to call the more standard type of continuance request is filed at least 7 days before the hearing. And if you have one of those more standard types of continuance requests, then it must be filed in writing. That writing should specify the grounds for the request and the position of the other party, or explain why you don't know the position of the other party. And I think sort of baked into that standard is that the parties should be talking, that if you need a continuance, you should be contacting the other party to determine whether they oppose it, and if they do, why they oppose it. And the standard for assessing one of these one of these types of continuance requests is good cause. We've heard that term before earlier in the presentation. It means essentially the same thing here. It's once again a flexible standard, depends on the case, but things like uh, you're not seeking sort of an unreasonable delay in the hearing. Something unexpected came up that wasn't anticipated when the case was originally scheduled, and you had some sort of attempt to hold the hearing as scheduled, but you just can't for one reason or another. That good cause reason is weighed against any opposition from the other party, any prejudice that they might have for delaying the hearing. Now, the second type of continuance request is if are those that are made fewer than 7 days before the hearing. If you're filing a request for continuance under those circumstances, I like to think of this as sort of the more emergency rule, such as, you're driving into the hearing and you got into a car accident. Your witness was unexpectedly sort of laid up in the hospital a couple days ago. That you just didn't know you needed a continuance until something immediate and emergent happened. In those types of situations, it's still preferable to file your continuance request in writing, but you do have the option of filing it orally or making it orally, but you have to explain why you couldn't make it in writing. For example, I'm in the hospital. I don't have access to my computer. I can't type up a motion right now. In addition to that, you have to explain why you were unable to make a more standard request, why you couldn't make the continuance request earlier. And then the other components are very similar to the other type of continuance request. Specify the grounds for the request, why you need it, state the position of the other party, or why you don't know the position of the other party. And if you look at the end of this slide, these types of continuance requests are granted for extraordinary circumstances. That's a higher bar than good cause. It's something really out of the ordinary, something really dynamic and emergent that you just did not see coming. And that's once again weighed against. It has to outweigh any prejudice to the other party. So I think it's a sort of a good rule of thumb to think about it this way. The closer to the hearing you get, the more difficult it's going to be to get your continuance. And moving on to abeyances. Abeyance is another very common type of request that we get. An abeyance is essentially a temporary pause on all events, deadlines, other case activity for periods of up to 6 months. Now, this is a rule that changed in the last 5 years or so. It used to be a pretty loose standard. Cases can go into abeyance and stay in abeyance for who knows how long. Yeah. But more recently, the board has been tightening up the standard with this new version of the regulation. And, here's what an abeyance does. So when an ALJ gets the case, it's their job to move the case forward, hold the hearing as efficiently as possible, complete the hearing, and then issue the decision. So the ALJ is constantly looking to bring the case to conclusion. If there's a reason to sort of take a timeout and stop the clock, then you should make that request to the ALJ. Currently, the rule is parties can seek an abeyance for up to a 6-month period. That abeyance period can be extended by agreement. Parties can agree to extend the abeyance. And PERB can always issue an abeyance order of its own if there's a reason on PERB side to delay or pause the case. And keep in mind, although parties can, by agreement, extend the abeyance, if the abeyance is going to last longer than 2 years, and that's cumulative time, you do have to make that request to the board itself, not to your ALJ, not to the OGC. You have to make that request to the board itself and explain why you need it. And sort of common reasons for an abeyance are parties feel like they're close to reaching a settlement agreement. there's related litigation that just hasn't caught up to where the parties are in this particular hearing. And so there's a reason to pause case activity and explore those things and sort them out.
Okay, one of the final issues that we want to discuss as part of our pre-hearing preparation recommendations is the preparing and interviewing of witnesses. And I know I say one of the final issues that we're going to discuss. This doesn't mean it necessarily has to be the last step in your pre-hearing preparation process, although I will admit that for some practitioners, it is often one of the last things they do. Nevertheless, wherever you decide to fit in a witness interview or meeting, there are advocates may wish to meet with their potential witnesses for a variety of reasons. First, interviewing witnesses early may reveal strengths and weaknesses in your case. Not only that, it can help you assess memories. There have been numerous studies over the recent years which show that witnesses' memories tend to fade over time. So it's good to get a sense of who your stronger witnesses might be in a hearing before you call them to testify. Alternatively, it can help the witness to feel more comfortable or more articulate during the hearing process. Another reason you may want to meet with your witnesses is to find out the witness's availability and whether an interpreter may be needed. Now, as a reminder, it's best to contact your witnesses early in the process to address scheduling conflicts early. But by this point, if you haven't done so already, it's a good idea to address this issue as well by at least the time you are meeting with your witnesses. And finally, for virtual hearings, meeting with your witnesses presents a good opportunity to make sure they know how to use the equipment and programs. If you decide to meet with your witnesses, there are multiple things that you can do in that meeting. One of which is to explain the role of the witness to the witness. You can explain their connection to the case and why their testimony matters. Um, the advocate's role is really to extract the facts from the witness, and it will be the witness's opportunity to truthfully testify as to relevant facts and circumstances. Now, we have a few quotes here, but it is important to remember that a lawyer may interview a witness for the purpose of preparing the witness to testify. However, a lawyer shall not counsel or assist a witness to testify falsely. And these come to us from the third restatement of the law governing lawyers and from the California Rules of Professional Conduct. Also under the rules of conduct is an attorney's duty of candor to the tribunal before which they're appearing. So yes, it is not uncommon to meet with a witness before the hearing, but there are certain special considerations which you must keep in mind. There's a tension between these two rules here, I would say. And one of the ways I best like to think about it is that advocates may explain to witnesses how to testify, that they testify truthfully, encourage them to speak concisely, but they should not tell the witness what to say. So some common advice given when meeting with witnesses, you will see that all of these options really engender credibility for the witness. Encourage your witnesses to answer truthfully, to only answer the question that is asked, and along with this goes not to answer the question they wish had been asked. Again, if a witness is being more forthright, more forthcoming, it lends itself to their credibility. They might also be advised to wait for the entire question to be asked and then pause before answering to consider their answer and put forth a concise answer. Clarify any unclear questions. You want to avoid assumptions. Don't guess what the question was asking about. Don't guess what the answer may be. It's okay if you need to ask, hey, I don't understand the question. Could you please clarify? Another piece of advice, tell your witnesses, give only your best present recollection. Do not volunteer information or guess. And it's okay to admit to a lack of knowledge where appropriate. I can't tell you how many hearings I've been through where it's become apparent that a witness, for some reason or another, finds it incredibly difficult to admit that they don't know an answer. And then later in their testimony, it becomes clear that their testimony may not be as reliable as it seemed, which impacts their credibility and lengthens the hearing process. Finally, in meeting with your witnesses, it's important to discuss effective hearing room dress and demeanor. Explain to your witnesses what they might expect and how to dress. Advise them to keep their conversations, their tone, their actions professional, even when they're dealing with a difficult circumstance or opposing counsel. And let them know that objections and cross-examination, they're just part of the process. It's not a reason to get defensive or to take personally. We have a very different way of speaking with each other in a formal hearing. It's not as conversational. We're just trying to move through the facts as efficiently as we can. You might also choose to review the subject matter with them of their testimony. So helping the witness to understand how to testify truthfully. And you can do this in a number of ways. You might highlight general topics or points to cover, sort of a 1,000-foot view, and just quickly moving through the preparation with them. You might also wish to review specific questions point by point, so that they get a better sense of what questions you're going to ask and the answers that they might want to give. Now, I would caution you that if you are going to go point by point with your witnesses, you want to avoid sounding too rehearsed in their testimony. You also want to consider asking your witnesses the hard questions that they might anticipate receiving on cross-examination so that they aren't surprised by them during the hearing. You may also wish to review key documents with your witnesses, practice laying the foundation with them so that you can move efficiently through that process and get to your more substantive examinations of your witnesses. And finally, as a reminder, do not tell a witness how to testify. And then lastly, it goes without saying, but I would also advise at the end of your meeting with any witness, answer any questions they may have. Give them an opportunity to get any concerns they might have out there and discuss that with them. Okay, and always, as always, you've heard this several times now, there are the general rules, and then there are special considerations that go along with interviewing your witnesses. So there are rules about employers seeking to interview their employees about their protected activities. And this is particularly true in areas regarding union representation and information disclosure. PERB has opined on this on numerous occasions, but we have two recent decisions here for you. Victor Valley Union High School District 2022, PDN 2822, and the City of Commerce 2018 PDN 2602M. Now, in the City of Commerce, that involved a disciplinary arbitration separate from the matter before PERB, and the attorney was interviewing two employees who had been subpoenaed by their union. And during the interview, the employer's attorney asked the employee if they knew why they had been called to testify in the matter. PERB found that question to interfere with protected rights and discuss the importance of what we call a Johnny's poultry warning. In that case, if you were really interested in what a Johnny's poultry warning is, you can go look at it. But it comes to us from another National Labor Relations Board decision. And in the more recent decision of Victor Valley, again, a union president, the parties were preparing for a teacher dismissal issue or matter, and during a pre-hearing meeting, the employer's attorney asked the union's president about confidential communications with the unit members during the deposition. So PERB again found that to interfere with protected rights and issued a test, which is important to keep in mind during your interviewing of witnesses. It is a three-part question or a three-part test. First, the question must be relevant to the matter at hand. It must not have an illegal objective, and the employer's interest in obtaining the information must outweigh the employee's interest in their protected rights. And the employer in this case lost on that final point. PERB found that the employer's interest did not outweigh the protected interest in confidential communications with one's union. So special considerations to keep in mind in any meeting with witnesses.
Well, you managed to make it to the end of our presentation. We do appreciate those of you who stayed to the very end. I know we went just a little bit over the allotted time, and so I do hope that you found the extra detail that we tried to get into useful. We do hope that practitioners, both new and old, no matter what your experience level is, found something useful in our presentation. And we ask you to please join us on May 14th for our next webinar about the overview of the unfair practice charge process here at PERB, from the initial filing to the issues of the issuance of the complaint or dismissal. We don't have time to take questions live today, but if you do have questions about anything we covered or about our process, please do contact perbquestions@perb.ca.gov. Thanks so much for your time.